Yeah, you can bring them out now.
Morning, Ron.
They did not.
We just need to change the language. We need to where this is, take it like that. That's fine. It's not, we just need to weigh up the not, or I need to officially trust that position. So I don't know why these- why we kept going. This is docket 23-934 FC, people of the state of Michigan versus Jacob Montalvo. Counsel, your appearance for the record.
Thank you, Sarah pulled on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Flagelston on behalf of Jacobo Montalvo, standing to my right.
Thank you. Sir, do you go by Jacobo or Jacob? I have a note, Jacob.
Jacob, Your Honor.
That's what I have. Okay.
Thank you.
Thank you. Now, is that your lawful name, Jacob, that you got wrong, or is that?
It's in Spanish, and in Spanish, the O is Jacobo, and it's pronounced in English, and O is silent.
Okay, okay, so we have the spelling right, just. we need
Yeah,
to-
it's spelled in Spanish, but it's pronounced with the O is silent. And
Okay.
in English, it's Jacob.
That's what my notes said, but thank you for clearing that up. All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am, Your Honor.
Thank you. Put your hand down. You have a nice deep voice. You don't have to keep leaning forward. We got the microphone there, so we're good. Have you taken any medication yesterday or today?
No, well, for heartburn
Yeah.
and for diabetic.
Okay, so is it anything that would interfere in your ability to understand the court or your attorney?
No, Your Honor.
And sir, is there a medication that you're supposed to be on that you are not on?
No, Your Honor.
And any sign of fever, COVID, or other illness?
No, Your Honor.
You've had an opportunity to speak with your attorney,
Yes, Your Honor.
and you understand this is a final criminal pretrial, meaning you have to make a decision as to whether you want to accept any plea offer, if there was one. I don't know if there was one. And if not, we simply set this for trial. I don't allow, as a general rule, once in a while there's exceptions for odd reasons, but I don't allow pleas on the day of trial, because then somebody else is denied that day and week for trial. So I like to keep those dates. So do you understand this is the deadline?
I understand, and I believe we're ready, Your Honor.
Okay, so you've had enough time to speak with both of your attorneys?
Yes, ma'am.
Okay, very good. On behalf of the people, was there an offer?
There's no offer, Your Honor. Thank you.
All right, are we ready then to go to trial? There'll be no plea?
That's correct, Your Honor.
Yes, Your Honor.
Honor.
Thank you. And sir, that's correct, you want to go to trial?
Yes, Your Honor.
All right, and Did anyone force, threaten, or coerce you to make this decision?
No, Your
Did
Honor.
anyone promise you anything that caused you to make this decision?
Negative, Your Honor.
And you are working with both of your attorneys toward trial,
Yes, Your
and
Honor.
you're satisfied with their representation?
I believe so.
Okay, and do we have a trial date?
Yes, Your Honor, it's May 29th.
And do we know, will this be a 1 week or 2 week?
I would expect that it would go into 2 weeks.
Okay. Thank you. Council agrees with that.
Yes, Your Honor.
Yes, Your Honor.
Is there anything that you are still awaiting that you need for trial? Are there any motions we have not? I know this file's rather thick. I know we've had motions and other things in the past. Is there anything we need to address prior to trial so we are ready to go?
Judge, I believe there are no additional motions, and I believe we have all the discovery necessary to proceed to trial on the 29th. I'm not ready to proceed.
Thank you. And you will all work together then for jury instructions
Of course, Your Honor.
and then make the court aware of whether or not you want the jury to ask questions, and then we'll deal with sequestration motions and other issues at that time.
Correct, Your Honor.
Yes, Your Honor.
All right, is there anything else we need to address?
No, thank you.
Sir, do you have family members who could bring you civilian clothes? You can't be in trial in those.
No.
Okay, the prosecutor does have access to clothes, so,
The public defender.
Judge,
I'm
we've
sorry,
worked
the
with-
public defender has access to clothes, so we're going to, you'll need to work with them and get some outfits for every day of trial. Okay,
Judge,
do that?
we've worked with him, and we have his clothing size. We'll make sure he has clothing. We have a whole closet of wardrobe for
Okay,
defendants. Yeah.
all right,
I appreciate it.
you're good with that? Okay, anything else we need to address?
No, Judge, I think we're satisfied. Everything that's been laid on the record.
Great, I will see you May 29th for trial.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Next is gonna be Theodore Krupp.
All right, what was the next one?
Theodore Krupp. It's at 9 o'clock.
This is docket 253909FH, People of the State of Michigan versus Theodore David Krupp. Counsel, your appearance for the record.
Good morning, Your Honor. EP Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Alexander Rusk on behalf of Mr. Krupp, who's standing to my right.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you, and put your hand down. Sir, have you taken any medication, used any alcohol, marijuana, over-the-counter prescription meds yesterday or today?
No.
Is there anything you, I'm sorry?
No, Your Honor.
Is there anything you're supposed to be on that you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your
And you've had enough time to talk with your attorney?
Honor. I have.
And I understand there's going to be a plea today, so you're waiving your right to a jury trial?
Correct.
And sir, do I have the address correct? I have you in Chesaning on Pearl, is that correct?
Correct.
And who do you live with?
Myself.
And are you employed?
No, Your Honor.
Are you retired?
No, Your Honor.
How do you support yourself?
Savings.
Okay, and you're able to do that?
Yes, Your Honor.
Okay. At the time of the offense you're pleading to, were you on probation, parole, or bond conditions on another file?
No, Your Honor.
Are you a US citizen?
Yes, Your Honor.
And you've had no time to talk with your attorney about all matters?
Yes.
What is the plea agreement?
Yes, Your Honor. The defendant will be pleading to an added count 2 of operating while intoxicated second offense notice, which is a 1-year misdemeanor. Upon successful plea and sentencing, count 1, OWI third, will be dismissed. There was also an agreement between the parties for the defendant to serve at least 24 months of probation with no earned early release.
24 months probation. So So without it being cut in half, you mean?
Correct, Your Honor.
So, okay. So just kind of an odd way to say it, because it'd be discharged now.
I
Yeah,
understood.
no problem, just want to make sure I got it clear,
Yes,
that it's probation, not jail.
yes.
Okay. Is there any conversation for sobriety court?
Yes, Your Honor, I can address that. As Mr. Krupp lives in Chesaning, we've had some serious issues for sobriety court. So he was approved for 55th, qualified, but the travel about an hour and a half, multiple times a week potentially, they ruled him that just wouldn't be workable.
Does Chesaning have a sobriety court that he could avail himself of that we could work with, or no?
No, Saginaw has a sobriety court and a mental health court. They have been full or not accepting transfers. Same is true in Shiawassee County as well.
That's fine.
But we definitely wanted to get into one of those programs. That's how we reached our resolution here.
And Your Honor, that's why we did the 24 months probation.
Okay. So let me just say in the future, when we have this kind of deal, I want him to have the plea in district court, in 55th district court, and be, or whatever district court, and be monitored by the district court probation, which is much more hands-on, has the resources, and also can refer to some of the resources that sobriety court has. I don't want to waste anybody's time, so we're going to do it this way. But in the future, that's the way to go, not this way.
Thank you, Your Honor.
Understood, Your Honor.
Counsel, is that full, fair, accurate, and complete?
It is, Your Honor.
Full, fair, accurate, and complete, sir?
Yes, Your Honor.
All right, thank you. And counsel, you're waiving count one,
Correct.
as to count two.
Yes, Your Honor. People of the state of Michigan versus Theodore David Krupp, State of Michigan, County of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant, in an added count two, operating while intoxicated second offense notice, did operate on or about March 1st, 2025, at East Holt Road and Zimmer Road, Williamston, Michigan, 48895, Ingham County, State of Michigan. The defendant did operate a vehicle in, at, or near the 1400 block of East Holt Road, a place open to the general public or generally accessible to motor vehicles, while having an alcohol content of 0.8 grams or more per 100 milliliters of blood, contrary to statute. Restitution. This offense may resulted in damage to another individual's property or physical injury or death to another individual. Second offense notice. Take notice that the defendant was previously convicted of operating impaired on or about May 17th, 2007 at the 66th District Court and operating impaired on or about February 24th, 2023 in the 70th District Court. Therefore, upon conviction, the defendant will be subject to the enhanced sentence under MCL 257.6259 or MCL 257.62511 and vehicle forfeiture under MCL 257.625N. This is a misdemeanor that's punished by up to a maximum of $200 to $1,000 and 5 days to 1 year in jail, or 30 to 90 days community service, or both. Rehabilitative programs per statute, cost of prosecution, reimburse government for emergency response and expenses for prosecuting defendant, see statute. Vehicle immobilization mandatory, see statute, unless the vehicle is ordered forfeited under MCL 257.625N. A term of imprisonment imposed must not be suspended unless the defendant agrees to participate in a specialty court program and successfully completes the program. And against the peace and dignity of the state of Michigan.
Is this one with the 60-day current suspension or no? Does it say in there?
It does not, Your Honor, but because this would be 2 within 7 years, it would be the automatic revocation.
Okay. Thank you. Sir, did you understand what was just read?
I do.
So you understand that this is the operating while intoxicated second is a 1-year misdemeanor. And for $201,000 in fines plus costs, I don't know if there's any request for cost recovery for any ambulance or police, etc. We'll figure that out at the end, and there's 5 days jail, up to the 1 year, and then 30 to 90 days community service and vehicle forfeiture or mobilization. So you understand all of that?
I do.
What's the status of your vehicle?
You were driving on that?
So, yeah,
What is it? Do you still have it? Is it been immobilized?
I guess you could say that I still own it. There's been a problem with the mechanics of it, the engine, and it's,
So it's immobilized by virtue of not being able to be used?
that's correct.
Okay. And sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did you understand what you read?
yes, I did.
And if you had any questions, your attorney was able to answer those?
He was.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
I did.
Did you understand what you read?
I did.
And again, your attorney was able to answer any questions you might have had?
He was.
Do you have any questions about your rights at this court?
I do not.
And you also understand that you're giving up your automatic right of appeal if you choose to appeal. You first have to ask permission of the Court of Appeals to appeal, and it becomes their choice. If they think your issues are important, whether or not they take up your case. Do you understand that?
I do.
All right. Sir, as to count 2, operating while intoxicated, second offense, how do you plead?
Guilty, Your Honor.
And sir, has anyone told you what I will do at the time of sentencing? Other than the statute?
No, Your Honor.
And that's because I don't know. I will make up my mind at the time of sentencing. Do you understand that?
I do.
All right. And sir, at this time, I'm going to ask you some questions, and counsel may jump in and ask some questions as well. As to count 2, did this offense occur on or about March 1st, 2025
Yes, Your Honor.
in the township of Wheatfield County, Mango State of Michigan?
Yes.
You came in contact with law enforcement at a specific location known as East Holt Road and Zimmer Road?
Yes.
And did they stop you because of your driving?
Yes.
And it's fair to say that prior to getting into that vehicle, you consumed alcohol?
Yes.
Do you remember what you consumed?
Roughly 7 drinks.
Like hard liquor, beer, what?
1 hard liquor and the rest beer.
Okay, and what was the time period that you drank that over? Do you remember?
I do not recall.
Okay, and it's fair to say you would have driven better without the alcohol.
Yes.
And the officers pulled you over, you pulled over, and then did they give you a breathalyzer?
Yes.
Do you recall the reading of that?
0.17, I believe.
And did you also do the field sobriety test? Did they have you do the walk and turn?
Yes. Your Honor.
Okay. And then they took you into custody, determining that you were intoxicated.
Yes, Your Honor.
And you're not disputing the 0.17, is that correct, counsel?
Correct.
And you would agree, sir, that that is over twice the legal limit?
Yes, Your Honor.
And you had operated your motor vehicle while intoxicated on roads that were open to the general public?
Yes, Your Honor.
And did you end up having an accident or hitting someone or something?
No, Your Honor.
All right. Thank you. How many have good people? As to this, I'll ask about the prior offense, but as to this, anything further?
And without the prior offense, I believe we're satisfied, Your Honor.
Counsel?
I agree.
All right, and sir, you previously were convicted of operating while impaired on or about May 17th, 2007 in the 66th District Court.
Yes, sir.
All right, and for purposes of it, the 7 years, there's also one on February 24th, 2023 in the 78th District Court. Correct, all right. Any additional questions on behalf of the people?
People are satisfied in regards to the notice, Your Honor.
No, Your Honor, thank
All
you.
right, and you understand because it's a second offense, a first offense is a 93-day, but you have that enhancement to the 1 year because your prior offense, you understand that?
Yes, sir.
All right. Our counsel where premises, threats, or inducements other than those already placed on the record,
No, Your Honor.
No, Your Honor.
this court comply with court rule.
You have, Your Honor.
It has, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there is sufficient grounds to accept defendant's plea. Therefore, count 2 will enter, count 1 in its entirety is hereby dismissed. Any outstanding warrants, if any, are hereby recalled and dismissed. The vehicle will be immobilized within the next 7 days, and you'll show proof of that. You can talk to your attorney about how to do that. It can stay in your garage if it's truly immobilized and not fixable, or you can have it carted off somewhere, but we need it to be immobilized for the statutory period. And do we have a sentencing date?
June 23rd at 9:30.
Does that mean with your schedule?
It does, Your Honor. We're also prepared to go into immediate sentencing if the court's amenable.
Sure, if there's no damage, so there's no reason why not to.
He was out in the middle of the field, Your Honor, so I would agree with that. There's no restitution in regards to that. I do believe there is restitution that. I do-
Cost recovery?
Yes, correct, Your Honor, for the request for restitution from the Sheriff's Department. I have a total of,
Is that Ingham County or Williams?
that would be Ingham, or it would be, yes, Ingham County Sheriff's Office, Your Honor. I have a lodging cost of $25. I have. I apologize, I did not write this very clearly. Average monthly vehicle cost is $1,834.30.
I'm sorry, $1,034?
$834.30.
$834 for vehicle.
For the vehicle, including maintenance, gas, and insurance for the vehicles that were used by officers. Average monthly mileage for the vehicles,
Your Honor, I think I would need a chance to review if we're talking about $2,000 in cost recovery.
and I would have no issue with,
Yeah, it's usually not that high, and there was no accident, so I really just don't know. So what we're gonna do is have cost recovery. We'll keep it open. If you all agree, that's fine, and if not, I will make a determination at a hearing. So can we do it that way?
Yes, Your Honor.
Okay, great. All right, on behalf of the people, what would you like me to know?
yes, Your Honor, as you are aware, we typically don't do these types of agreements for an OWI third. I did have a chance to run this by the elected, so there is an approval on this type of agreement. But with that being said, that was with 24 months of probation. Mr. Krupp obviously has a drinking problem with his with two prior OWIs, one being from 2023. And Your Honor, as you had heard, the PBT was 0.17. However, when they did the blood alcohol content, it did come back, Your Honor, at a 0.215. So I believe Mr. Krupp has a very serious drinking issue that needs to be addressed immediately, Your Honor. So I would ask that you follow the agreement of the 24 months of probation with whatever mandatory requirements under the statute else you need to give him. Thank you.
Thank you. Counsel?
Thank you, Your Honor. I think that Mr. Buxton covered some of our concerns there. As background, though, about Mr. Krupp, he is born, raised in Michigan, originally from Owasso. He's divorced, but he still has interactions with his children, of course. He's a graduate from New Lathrop High School, and he also has his associate's degree from Baker College. As the court can see, this case has been pending for a little bit of time here. Mr. Krupp, from basically the first time that we talked, I believe that would have been back in March of 2025. He has been willing to engage in any specialty court program, and he's been assessed for multiple of those programs. We've been able to address both sobriety as well as mental health issues in the interim. Fortunately, without those mental health courts not being available, but Mr. Krupp has made significant strides from where he was a year ago, Your Honor. He's not violated bond, he's not failed to appear, he's been in constant contact with myself, and this is the first time that he has been charged with a felony. In addition, Mr. Krupp also has provable sobriety for the court here today. He's been on a scram tether for about a year at this point, and no issues. I've not seen any alerts as far as even a battery dying, and certainly no positive tests there. As he's been complying with the rest of his pre-release conditions, Your Honor, I ask that the court sentence him to the 24 months, allow him to complete the community service in place of any jail time. Mr. Krupp, he doesn't need an impact weekend or anything like that, Your Honor. He's had his life really turned upside down since this case and some other issues arose last year concerning mental health. Fortunately, he is in a much better spot. He's taken steps to address those issues. And I don't think that he's going to be a person that you're going to see again during this probation period. I've got no indication that he'll do anything but be compliant. And as I mentioned, if we could have gotten into a sobriety court, that would have been just a great opportunity. As we know in this case, he's not going to have his license back before petitioning the Secretary of State. That can take quite a while. It's certainly not the phase 1, phase 2 of sobriety court where you can get that restricted license. So I do appreciate the people who've been able to work with us. This was unfortunately a situation where specialty courts could be of a great assistance. And just personally, I think that we need to keep expanding them, but unfortunately, that's where we are today. But Mr. Krupp's taking responsibility, Your Honor. He's addressed his alcohol use issues. He also has been diagnosed as an early remission as far as that alcohol use disorder. He was assessed by Dr. Smith at Wellness Inc. That was provided to the people. And it addresses, I think, the concerns that the people had, which is, of course, alcohol use going forward here. The court has sufficient resources to make sure that Mr. Krupp complies. I don't think that you're going to have to use any of those additional resources, Your Honor. Again, no real concerns about Mr. Krupp being able to complete probation in this case, really get things back in line and, get back to his life in a new, better form of himself at the end of the day. Thank you.
Thank you. Sir, what would you like me to know?
Fairly accurate what Mr. Russick just told you. Went through some pretty traumatizing times in my life and unfortunately just ended up here. You're not going to see me back.
So are you in counseling currently? Were you, what did you do to get, what have you done in the last year in terms of addressing the substance abuse and the underlying factors?
Been through multiple AA classes and meetings and
Are you
also
still going?
currently I'm not because of the license issue. If there's something online or something that I could get involved in, I'm not opposed to that. Not being able to drive should allow the time, and mental health because of the situation of a divorce is much more in line with what the general public would expect.
And so are you currently in therapy with someone in regard to those, that trauma of the divorce and whatever related issues?
Currently, I have not.
Did
It
you
is
go to?
completed.
You completed it.
Yeah.
Did you have a substance abuse assessment
Yes, Your Honor.
and you followed the recommendations?
Yes, Your Honor.
Mr. Krupp also completed the highway safety seminar as well, Your Honor.
Sir, it's never okay to drink that much. You certainly have a problem. It's also not an answer to drink away your problems. Asking for help is a sign of growth, it's a sign of strength, it's a good sign all the way around. Finding answers in the bottle gets you nowhere except in front of a judge or a body bag. So I hope you've learned that lesson.
I have, Your Honor.
What else have you learned?
Grief and trauma are pretty hard to deal with and should have reached out for help previous to trying to solve situations on my own.
Can you do that now?
I can, Your Honor.
Do you have a support system in place?
Yes, I have a pretty good sized family that's supporting me and, yes, I do have things in place.
And how did you get here today?
My brother.
Sir, I'll put you on that 24 months probation. You've been on a scram tether for what, a year? I'm gonna remove that. How do you feel about that?
That would be appreciated. One, because of the discomfort of it, and two, because of the cost. And three, you won't have a problem with it.
Well, sir, you will have to submit to any testing that probation wants. You'll not adulterate any test. If you are positive, then we will do a secondary test to see if it was a false positive or a positive positive, okay?
Okay.
You need to keep us apprised of all medications. And, you know, sometimes there's alcohol in certain cough syrups or other things. So make sure doctors know that you have a problem with alcohol. If you end up having a prescription, you have 24 hours to tell us what you're taking so that if it shows up on the test, we know that it's lawful. It's up to you to not eat or drink things with alcohol. So you go to someone's house, you don't know what's in the fruit punch, you don't drink it or you find out. Okay? You are not to be in the presence of any alcohol. You'll not be at any bar. You can go to restaurants like Red Lobster has a bar in it. You won't be sitting in that bar. You can sit in the restaurant. So where the primary business is alcohol, you cannot go. You can't go to a liquor store. Could you go to Myers and they sell alcohol? Yes, but you can't buy any. Does that make sense to you?
It does, Your Honor.
The cost recovery is held in abeyance pending agreement or hearing. You will pay a $50 state cost and a $75 crime victims. Those are not waivable. You can arrange a payment plan if needed. You are not working, so I'm going to waive probation oversight fees. You will not violate any criminal law of any unit of government in this state or any other. You'll not leave the state without permission of this court. You will make a truthful report to probation at each contact, and because of the distance, this can be transferred to Chesaning, or you can simply meet with probation over Zoom. But you first have to meet with probation here, and then they would contact probation in Chesaning, and then you could do it that way, or they could meet with you, but Chesaning doesn't know anything about you right now, so you first have to come here, then we work with them. Does that make sense? So, and I don't know if there's probation in Chesaning or if it's Saginaw, or if you just prefer to do it here, but you work all that out with probation, okay?
Okay.
You'll not use, possess, purchase, or be in the presence of any firearm, ammunition, or other dangerous weapon. Your vehicle, as we discussed, must be immobilized for the requisite period. I suspect you already received, and if you haven't, Secretary of State will be revoking or suspending your license for the requisite time period. Do you understand that as well?
I do.
You'll take the highway safety class, and you've already done that, so I'm giving you credit for that. You were already submitted to counseling, so I'm only going to order counseling. If you end up with a positive, then you will be back in intense therapy, possibly residential. AA, NA, or CA, you will go at least one time per week and you'll find a sponsor who you get along with and can call if you have the urge to drink or something's going on. And I want that sponsor to have worked a program and gotten sober through that program and have 5 years under their belt of sobriety. They'll have a sponsor within 6 months. Tell me about employment. Are you planning on retiring? You just didn't get employment because you don't have a license or what?
It was due to the license, correct?
Okay,
Yeah, I was employed, it just say.
well, what's your line of business?
I was in machining, manufacturing,
Okay,
and, yeah,
that's a good job. You can't take an Uber or get rides from friends? Here's the thing, sir. I don't know if you're near retirement or what. I don't know what your financials are. I don't need to know. What I do know, I used to be the sobriety court judge in 55th District Court, and I've seen a lot of it since then in my 22 years on the bench. And I do know, especially for men, especially for someone who's always had a job, being the breadwinner, all those things, that work is a good thing. Now, I don't know if you have a hobby, if you go bowling every day, or you go for long walks, or what you do, but sitting around is not going to be good for your mental health. Now, if you are retired and you want to play with grandkids or do whatever, that's fine. But if you're used to working and you need a purpose to get out of bed and not feel sorry for yourself and have a group of friends and all of those things that come with work, then you need to get back to work. So I leave that up to you and probation, but I'd like to see you figure out a way to go back to work. I bet there are friends that would pick you up and drive you or take an Uber. Certainly with the kind of job you had, you could afford Ubers. Or to pay a college kid or a high school kid to drive you to work and pick you up. They probably love to do that. So you decide what you're going to do, but I want to know that you are filling your time being productive.
understood.
I think that goes hand in hand with your mental health. I'm not a therapist, I'm not your therapist. But idle hands have a way of causing depression, anxiety, other things, withdrawal, and all of that leads to drugging, drinking, and bad habits. I
Understood.
want something that uplifts you. Maybe it's meditation, yoga, I really don't know, but you work that out with probation. I'd like to see a plan for your continued sobriety and healing. I think it should include work. You don't look old enough to retire to me. Maybe you've already earned your millions, I don't know. But work's a good thing no matter what your income is, so figure it out, sir. Once you're employed or in whatever program or hobby or whatever it is you decide to fill your time with, you will steadily do that and need permission to change that roadmap. You'll work with probation or trained therapist to figure out where you go from here. Sounds like you don't really have a plan, maybe you have some ideas, but let's get on a lifelong plan. You have a lot more life to live, and let's make sure it's productive, whatever you do. It's your choice. I want a plan and I want to see it executed. We'll be watching you for 2 years. You will not abuse any prescription or non-prescription medication. You'll not use any illegal substances or have any drug paraphernalia. You have, in terms of prescriptions, we've talked about that, you will have 48 hours to show all prescriptions to probation. You will submit to and pay for all testing and treatment. And as to community service work, sir, is there something near your home or something you'd like to do?
Nothing right on the top of my head, Your Honor. I'm sure I could come up with something if that's what I've been tasked to do.
Well, that's what the law says, 30 to 60 hours. And so I'm going to give you the 30 hours of community service, but or 30 days, however you work that out with probation. I'm sure there's a library or something that you could volunteer at, or maybe working with kids or other people in substance abuse treatment. I don't know, but you'll work that out with probation. How many days jail did you spend when you got arrested?
I believe it was like shy of 2.
So 2 days?
Well, I think.
Yes, Your Honor, 2 calendar days.
Okay, so the statute is mandatory 5 days, is that what this is, under 1 year?
It's 5 days to 1 year or 30 to 90 days of community service or
Alright.
both.
So I'm gonna give you 365 days jail. Credit for 2 days. The balance is held. You'll do those 30 days, or 30 hours community service. If you decide not to do those, we get jail for you.
Hours or days, Your Honor?
What does it say?
Because it says 30 to 90 days of community
So
service.
30 days.
Okay.
Is there anything else that I have missed that the people are requesting?
Only other thing, Your Honor, is that a substance abuse, it sounds as if he had taken a substance abuse assessment. I would ask that that be given to probation, so probation knows exactly what they're working with.
All right, so it sounds like you've already completed all the requirements, correct?
Correct.
All right, so just provide all of that, or in lieu of that assessment, a letter from your treatment provider saying what the recommendations are. So because you're required to follow those recommendations, so if they think that you're done and everything's good, that's fine. Does that make sense?
It does.
I'll provide it to probation promptly, Your Honor.
All right, and then proof of the highway safety.
Correct.
You have 42 days to appeal to request appellate counsel. Can you please hand him his appellate rights? They're right next to you. Do you acknowledge receiving your appellate rights?
I do.
All right, thank you, sir. So before you leave today, just to make it easy, go downstairs and make and keep an appointment with probation, and then if you'd like to transfer to Chastain or all that.
E3 Thompson, South.
All right, good luck to you, sir.
Thank you.
Thank you, Your Honor.
I think because of that, we should probably do Miles Thompson next.
Yeah.
Probably the call.
All right, this is docket 253502 FH, People of the State of Michigan versus Miles Lancelot Thompson. Counsel, your appearance for the record, there is also 25-6029 FH. Counsel?
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Morning, Your Honor. Jeffrey Kaplan, P74943, on behalf of the defendant who is appearing on Zoom.
All right, thank you. Mr. Thompson, can you hear me?
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. You had enough time to speak with your attorney?
Briefly, ma'am, yes.
Did you need more time?
Sorry, we spoke yesterday.
Did you need more time to speak with him today? I understand you spoke yesterday.
No, ma'am, I'm fine.
Okay, and sir, I understand you're at the forensic center. Are you in agreement with being there and not standing next to your attorney?
Yes, ma'am, I'm fine with that.
Okay, and I understand that this is the final pretrial. However, it's your choice that you are availing yourself today of taking a plea. Is that correct?
Yes, ma'am.
All right, and sir, are you a U.S. citizen?
Yes, ma'am, I'm a US citizen.
And you've been taking your medications, is that correct?
Yes, ma'am, I have been.
And those medications help you think more clearly?
Yes, ma'am.
Is there medication you're supposed to be on that you're not on?
Not at this time, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And at the time of whatever you're pleading to, which I'll hear in a moment, were you on probation, parole, or bond conditions with another court or judge?
I do believe I was on probation out of Inkster, Michigan, ma'am.
Is that correct, counsel? So was that at the time of this?
What I think.
No, ma'am,
he's re-
that was not.
Oh, it's a different event? Okay, that's fine.
Yes,
There's
ma'am.
no probation violation that I'm aware of that's pending anywhere.
So there's no open file that would cause this plea to be a violation?
Not that I'm aware of.
Not that I'm aware of either, Your Honor. The reason he's in the forensic center is due to a prior case that he has NGRI status on. So I'm not sure if that's what he was maybe confusing
Okay,
this all with.
okay, but he's been found competent for these purposes.
Correct, Your Honor.
Right. So
And criminally responsible.
Yes, that's correct.
Okay. All right, and sir, if you are released from there, do you reside at 607 East Michigan Avenue?
No, ma'am. That was a homeless shelter that I resided at.
Okay.
I would be back.
Do you have an address?
I would reside back on the streets if released from here.
Do you have any family, sir?
Not in this state, ma'am. All my family is out of state.
Where are they, sir?
My mother lives in Ohio, and I have an aunt that lives in South Carolina and an uncle that lives in Illinois.
Can you live with any of them?
I may be able to talk to my auntie about moving into South Carolina. My mother's already dealing with a lot by raising my niece, Your Honor.
My mother is
Raising
what?
your niece?
His niece Shauna, I think.
Okay, so, sir, before you're released, do you think you can talk to, or maybe probation can help you, or your attorney can help you talk with your auntie? I'm really uncomfortable with you living on the streets, because we need to keep you medicated and get all this handled.
Yes, I could live with my aunt, ma'am, probably.
Your Honor, just so you're aware, I think he's still got about 9 months left in the current treatment order, so he's gonna be there at least for that length of time.
Okay.
And then, of course, there's a possibility that the order will be renewed for another year.
Okay, so I just want him to start thinking of and reaching out to family, who knows he's in treatment, that everybody's gonna be safe, he
Sure.
can take his medication, because otherwise we're spinning our wheels.
Right.
So I know you've got a social worker, maybe you can jump in and help with this.
Certainly.
Great. Okay, thank you for all that information, sir. So I need you to just work with everybody, so when you are ready to be released, you are going to family, not the streets. The streets are gonna send you backwards again, okay?
Yes, ma'am.
Okay, great. And you're feeling okay on that medication? You're understanding everything?
Yes, ma'am. My understanding is precise.
Very good. And did you graduate from high school?
No, ma'am. I obtained my GED the year I was supposed to graduate.
That's good, that's great. Okay, great, okay. Counsel, what is the plea agreement?
Yes, Your Honor, the defendant will be pleading to count 1, assault by strangulation, be pleading to an added count 7, home invasion in the 3rd degree, and an added count 8, aggravated domestic violence. Upon successful plea and sentencing, count 2, home invasion 2nd, count 3, aggravated domestic violence 2nd, count 4, resisting obstructing a police officer, Count 5, stalking, and count 6, malicious destruction of a building less than $200 would be dismissed. As well as the habitual offender fourth status. And then Your Honor, I also, restitution will be determined at the time of sentencing in regards to the malicious destruction that's being dismissed. And those would be no contest pleas.
Okay, and then what about his other files? Is that being dismissed in its entirety?
Your Honor, I was looking in our system, I can't find another file for Mr. Thompson.
I have not been presented with another file.
Oh, okay. Okay, you know what? It's just somebody else with a similar name. No problem. So it's just this file. So the file that we're dealing with is 253502FH.
Correct,
All right,
Your Honor.
very good, thank you. All right, counsel, is that full, fair, accurate, and complete?
It is. I do want to add one thing. I did talk to my client yesterday. I said we would ask for COBs. When I spoke to Mr. Green this morning, he told me, and I see you're shaking your head, that you don't do COBs.
I don't do COBs
So-
because I don't like surprises.
Correct. And just so my client is aware, that's why I'm not presented with a COBs offer this morning. We can still make a sentence argument, of course, at the time of sentencing when you get the pre-sentence report. Otherwise, everything is as Mr. Buxton stated.
All right, sir, the plea agreement as was stated is full, fair, accurate, and complete. That's what you talked to your lawyer about, is that right?
Yes, ma'am.
All right, and I don't enter into, it is very rare that I ever enter into an agreement with counsel. They know me pretty well and what I'll do or what I won't do, but whenever I make agreements, you know, I don't even get police reports, and so I'm not fully informed. I like to be fully informed before I make up my mind, so that's why, sir. Do you understand?
Yes, ma'am.
Thank you. Counsel, are you waiving reading the habitual in its entirety along with counts 2, 3, 4, 5, and 6?
We'll waive, Your Honor.
As to the reading of the felony information, counts 1, 7, and 8.
Yes, Your Honor. People of the state of Michigan versus Miles Lancelot Thompson, State of Michigan, County of Hingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1, assault with intent to do great bodily harm less than murder or by strangulation. On or about May 13th, 2025, at 916 Pierce Road, Lansing, Michigan, 48910, Hingham County, State of Michigan. The defendant did make an assault upon Christine Charisse Bradford with intent to do great bodily harm less than the crime of murder and by strangulation or suffocation, contrary to statute. That is a felony that is punishable up to a maximum of 10 years and or $5,000. DNA to be taken upon arrest. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Added count 7, home invasion, 3rd degree. On or about May 13th, 2025, at 910 Pierce Road, Lansing, Michigan, 48910, Hingham County, State of Michigan, the defendant did break and enter or did enter without permission a dwelling located at 910 Pierce Road with the intent to commit aggravated domestic violence, a misdemeanor therein. This is a felony that is punishable up to a maximum of 5 years and or $2,000. And then added count 8, aggravated domestic violence, on or about May 13th, 2025, at 916 Pierce Road, Lansing, Michigan, 48910, Hingham County, State of Michigan. The defendant did assault Christine Charisse Bradford, an individual with whom he/she had a dating relationship without a weapon and did inflict serious or aggravated injury upon him/her, but without intending to commit murder or to inflict great bodily harm less than murder, contrary to statute. This is a misdemeanor that is punishable up to a maximum of 1 year and or $1,000. If the assault was committed in a place of confinement, the court may order the sentence for this offense to run consecutively to any sentence the defendant was serving or to the sentence for the offense for which the defendant was being detained. See statute. Court shall order law enforcement to collect DNA identification profile sample before sentencing a disposition if not taken at the time of arrest. and against the peace and dignity of the state of Michigan.
Thank you. Because I was looking at something else, the, count 7 is a 5-year with the possible monetary. Or home invasion third.
Yes, count 7 would be the added home invasion.
Yeah,
the monetary?
5-year annual.
Oh, I believe it is 5,000. Let me double check, Your Honor.
Okay, and then the DD is 1 year and or 2,000?
1 year and 1,000 for the aggravated domestic violence.
Okay, thank you.
And in regards to the home invasion, it is 5 year and 2,000.
2,000, okay, great, thank you. Sir, did you understand what was just read?
Yes, ma'am.
So you understand that assault by strangulation is punishable by 10 years or $5,000, and DNA is to be taken upon arrest unless it is already on file. And you also may be responsible for restitution for any personal or property damage. Do you understand all of that?
Yes, ma'am.
And home invasion third is a 5-year felony and or $2,000, again, that would be restitution if any, for any personal or property damage. And same with aggravated domestic violence. It's a 1-year misdemeanor and or $1,000, but also there's that restitution you may be responsible for. Do you understand all of that?
Yes, ma'am.
Now, sir, did you review the advice of rights form with your attorney?
Did not.
I have,
Okay, I'm gonna go over your rights, okay, sir?
yes, ma'am.
Okay, you have the right to have a trial by jury or by bench. You have a right to be presumed innocent until proven guilty beyond a reasonable doubt and to hold the prosecutor to their burden of proving your guilt beyond a reasonable doubt. And if they fail to prove that on any count, that count would have to be dismissed. You have a right to cross-examine any witnesses against you, and you have the right to order any witnesses that you want present in your defense, and the court would order those to be present. You have the right to remain silent at trial, and your sentence used against you in any way. However, you also have the right to testify at trial, and if you choose to testify, you would be subject to cross-examination. Furthermore, you have an automatic right of appeal if you have a bench trial or a jury trial, but if you choose to plead, which is what my understanding is you're doing, then if you are unhappy with anything, you have to ask permission of the Court of Appeals to appeal. Do you understand all of those rights?
Yes, ma'am.
And sir, you wish to proceed with the plea?
Yes, ma'am.
All right, sir, as to count 1, and this is going to be a no contest plea, is that correct?
Yes, Your Honor.
It is, Your Honor, for civil liability purposes.
All right, based on civil liability, the court will agree with that. And do you have a police report that I will be reading?
One was presented, I believe.
I did make an extra copy. I just gave you the copy that I had, sorry.
Oh, okay, that's all right.
All right. You may.
That was my
And
fault.
sir, you decided to plead of your own free will,
Yes, ma'am.
and you did that after you spoke with your attorney?
Yes, ma'am.
And you understand that if someone forced, threatened, or coerced you to plead or something has happened, you need to let me know now, because I won't allow you to withdraw your plea if you come back and tell me later you shouldn't have pled. Do you understand that?
Yes, ma'am. I agree.
And so you've pled of your own free will, or you're pleading of your own free will,
Yes, ma'am.
and that was after consulting with your attorney. Correct?
Yes, ma'am.
Okay, and you've been satisfied with the representation of your attorney?
Yes, ma'am.
All right, and you're pleading no contest based on civil liability to all 3 counts, correct?
Yes, ma'am.
So as to count 1, assault by strangulation, intended felony, how do you plead?
I plead guilty.
No, so
No,
we're
no, no,
gonna, I
no
know.
contest.
Great, okay, as to count 7, home invasion third, how do you plead?
No contest, Your Honor.
And as to aggravated domestic violence, how do you plead?
No contest, Your Honor.
All right, thank you.
Can I make a brief record?
Yes.
Thank you. One thing we kind of glossed over was the fact that we adjourned this so that my client could have an independent criminal responsibility evaluation. We did get that independent evaluation back. I forwarded it on to your court officers and Mr. Buxton. That evaluation found that Mr. Thompson was criminally responsible. I did discuss that with him and the fact that there is not going to be any not guilty by reason of insanity options. We did go to trial. And that was all explained to him. So we decided, that's why we decided to proceed with this plea offer.
All right, great. So did you hear what your attorney said?
Yes, ma'am, I did.
And you would agree with all of that?
Yes, ma'am, I am.
All right, thank you. Court has been provided Lansing Police Department Incident Report 25-0043. And it states that all right, counsel, you need to help me out here.
Sure.
Oh, wait, maybe I have it.
I highlighted a bunch there.
Okay, the felony information is incorrect, so when you present me with an updated one, it says on or about March 13th, and according to the various counts as well as the police report, it should be May 13th, so it should be 05.
I will fix that in the amended information.
Thank you. All right, the police report indicates that on May 5th, on May 13th, 2025, at approximately 12:46 hours, they were dispatched to 916 Pierce Road in regard to a stabbing. The victim was Christine Bradford, who was transported to McLaren Hospital. The accused, defendant Miles, was also transported to Sparrow Hospital for treatment of their injuries. The witness Dennis was transported to LPD for questioning. The location of the 916 Pierce Road is in the city of Lansing County, the state of Michigan. Officers arrived on the scene and witnessed a white male approximately 30 years old laying on a plastic bench near the stoop of 916 Pierce Road with stab wounds that were obvious. Officer applied pressure to the wounds to control the bleeding, and the accused was identified as Miles, and he was uncooperative and refused to answer officers' questions. The victim, Christine, and the witness, her mother, Denise, were located inside the Pierce Road address. Denise Dennis stated that she walked outside of 916 Pierce Road and noticed Miles standing next to Christine's vehicle. Christine told Denise that she stopped talking to Miles 2 days prior because he was stalking her. This prompted Denise to call Christine, who lives next door at 910 Pierce Road. Denise remained on the phone with Christine, who was located at 910 Pierce Road, where she lives. Denise was in the bathroom and heard Christine start yelling through the phone. She could hear that Christine and Miles were outside 916 Pierce Road in the yard. Denise advised that she had no idea what was going on, so she grabbed the knife she keeps near her front door and ran outside. Denise stated that Miles and Christine were located outside her front door just off the stoop, and Denise set the knife down on the brick ledge of the house next to the front door. Miles had Christine's hair in his left hand and was punching her with his right hand, which was in a closed fist position. Miles punched Christine approximately 7 to 8 times before Denise could talk him down. Miles released his grip and Christine kicked him away. Christine retreated to the door while Miles was walking at her. Christine grabbed the knife and kept it waist level at her right side, and Miles came at Christine attempting to strangle her. When Christine swung the knife forward, stabbing Miles in what Denise thought was the stomach area. Miles backed off momentarily, but then came back at Christine stating, "Do it again, I'm not going to stop." Denise stated that when she looked at Miles, she could tell he wasn't in his right state of mind, and Christine swung the knife again. Denise did not see where it hit Miles. Denise stated that police showed up just after and
Showed up just after and what?
took control of the scene.
Thank you.
During this time, Denise grabbed the knife and placed it in the kitchen sink to remove it from the situation. Matthew Carlson arrived approximately 12:46 after being dispatched to the 916 Pierce. Reference to the fight with the knife, and on scene made contact with victim Christine Bradford, gathered a statement and took photographs and provided her with a report number. He also gathered a witness statement from Michael Brooks.
Your Honor, if I may direct you,
Yeah.
the victim statement at the bottom of page 13. That's a little more of the important detail there.
Right.
Actually, if you go on to page 14,
Okay.
it talks about where he strangles her in that third paragraph down.
Thompson ran toward Bradford, who was on the front lawn near the porch of 916 Pierce. When Thompson got to Bradford, he put her in a headlock. While in the headlock, he punched Bradford multiple times in the face with a closed fist. Bradford stated he then took her to the ground. While on the ground, he continued to punch Bradford repeatedly in the face. While on top of her, he began to put both fists inside her mouth and separate her jaw, knocking her fake partial teeth out of her mouth. During the assault, Thompson indicated to Bradford he was not scared to go to prison or die, and he stated, "I hope you're ready to die."
The paragraph above that addresses the home invasion.
Bradford stated she then received a phone call from Thompson, who advised her that he just committed a home invasion.
Received a phone call from Thompson.
Who advised her that he just committed a home invasion and broke into 908 Pierce. He stated to her on the phone, "Yep, I'm committing home invasion." Then exited the front door of her mother's residence to go check on her cousin's house. When she exited her mother's house, Thompson was exiting the front door of her cousin's house at 910 Pierce. So specific locations would include, based on the report and the following information, would include the 916 Pierce Road, as well as the 908 and the 910 Pierce Road. I read so many. Nonetheless, all of the Pierce Road homes are in the city of Lansing, County of Bingham, state of Michigan. Yes, it's 908, 910, and 918. And Michael Brooks, who's a witness, is a property owner of 903 Pierce. And he also observed Thompson on top of Bradford punching her and choking her out. Do we need anything else? I think that is it, as long as council stipulates, and I think it's clear, but let's make sure council will stipulate that Mr. Thompson and Ms. Bradford were in a dating relationship pursuant to the statute, correct?
Yes, Your Honor, that is actually on the page above, on page 13, at the bottom of the police report.
All right, and yes, it does, on the victim statement, she stated she's in a dating relationship with accused Thompson, and he's been harassing her and trying to get back to her for a couple of days. As to the aggravated domestic violence, I think we have it.
That would be the bottom of the next page, page 14, in regards to her injuries.
I'm sorry, I did not hear you.
The bottom of page 14, it states what her injuries are. I do believe that would be appropriate for the aggravated domestic.
All right, I'll read them. I think it's clear from what happened to her, but it's, Bradford had head pain, blood in her right ear, as well as abrasions on her knees and her wrists. She also stated she had jaw pain and her partial tooth was completely knocked out of her mouth. Pictures were taken, they're attached to the police report, along with a lot of other information, so. Any additional information, they also have a number of witnesses, who made statements.
People are satisfied.
It's been said.
Thank you, we take your police report.
Thank you.
Our counsel, where promises, threats, or inducements other than those already placed on the record.
No, Your Honor.
Not for the time.
Have the corporal.
You have, Your Honor.
It has.
I find defendants no contest plea to be appropriate. I also find the plea was freely, voluntarily, knowingly, and understandingly made without undue influence, stress, coercion, or promises of leniency. I find based on the police report and the very detailed investigation that police did and all the interviews and the eyewitnesses, that there are more than sufficient grounds to accept defendant's plea on each count. Therefore, count 1, 7, and 8 will enter. Counts counts 2, 3, 4, 5, and 6
And the habitual.
are hereby dismissed along with the habitual fourth in its entirety. The court also finds that in talking with counsel as well as defendant, the defendant was coherent, has been taking his medicine, and clearly understood what was happening despite being in the forensic center anyway, it's right to be here. Therefore, this matter will go forward to sentencing. Any outstanding warrants, if any, are hereby recalled and dismissed. Any weapons or contraband that was seized are hereby forfeited. And what's the sentencing date?
June 23rd at 9:30.
Mr. Thompson, is it all right that we do the sentencing while you're still at forensics, or would you like to be transported here?
While I'm still at the forensics, I was hoping I could finish this year order up and then continue amongst what time is over my head, Your Honor.
Okay,
With what over his head?
with the time over his head. Is that what
I
you?
didn't hear that.
Sir, you hope to continue?
Say that
You want to
again,
be
Your Honor.
sentenced? Let me understand what you said. You want to be sentenced while you're at the forensic center, correct?
Yes, ma'am. Yes, ma'am.
And then you're going to be there for some time, so you'll have to be compliant then with the probation terms while you're at the forensic center. You're in agreement with all of that?
Yes, ma'am.
And is that what you essentially said that we didn't understand?
Yes, ma'am. And like finish out my probate order until sentencing to the prison commences.
Okay,
Commences.
okay, thank you. So, sir, probation is going to contact you there. You'll need to cooperate. They're going to do a very detailed sentence report that we'll all read and talk about at the time of sentencing, okay? I need you to comply with whatever they're telling you to do there, take your medicine, go to treatment, all of that, okay?
Yes, ma'am. 1 second, Your Honor. I have a question.
Yes.
Will the payments for my crimes, like the payments that I make the court payments and the restitution fees, will those can those wait until I'm out of prison?
Yes.
Okay.
Essentially, the restitution generally doesn't, I don't know if there's any restitution on this or what that's gonna be, but we're gonna talk about all that at the time of sentencing, okay?
Yes, ma'am. Thank you.
Okay, great.
Nothing else from the defense, Your Honor.
All right, thank you. In regard to bond, I'm gonna revoke bond. I don't think he's getting out anyway before sentencing, so I'm just gonna revoke it.
Okay,
So we don't lose track of the events for some reason he's released, okay?
okay, thank you, Your Honor.
Thank you,
Thank you, Your Honor.
thank you. Good luck to you.
Daryl Arnold, either here or on Zoom.
I'm appearing on behalf of Mr. Arnold.
We can do Daryl Arnold next. That's at 11:30.
But if Mr. Arnold's not here.
I don't know if Mr. Arnold's showing up. I don't know if it just his attorney was.
Ma'am, are you expecting Mr. Arnold?
I would expect him. I was not able. Oh,
Oh, he's the Motorola.
I'm here, miss.
Okay, just a minute, sir.
Yes, ma'am.
I missed it in order.
What is this?
Says I had a file, but it was missed. I don't believe so.
Is he?
No. Okay.
Do we have a blank one for me to read?
I'm about to go grab it real quick.
All right, this is docket 9061554FH. People of the state of Michigan versus Daryl Dwayne Arnold. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bar Buxton on behalf of the people of the state of Michigan.
and good morning, Your Honor. For the record, Dana Freers appearing on behalf of Mr. Arnold. I am appearing on behalf of Project Clean Slate.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Sorry?
He said yes.
Yes.
Yes, okay, thank you. You may put your hand down. On behalf of the people, have you received the requisite information from the state police and the attorney general?
Yes, Your Honor, the people have received both.
All right. Is there any objection on behalf of the people?
Your Honor, it looks through the letter from the Attorney General that he is eligible. So I would leave it in the court discretion.
Thank you. Counsel, is there anything you want me to know?
I would just indicate for the record, Your Honor, that my client is statutorily eligible. This is a matter from 1990, so certainly considerable time has passed. It does appear that he has had some contact with law enforcement, but almost all of those matters were dismissed. Any personal details I would leave to my client to relay to the court.
Thank you, sir. It's been what, 36 years? What have you learned from this? It's a long time.
I learned my mistake, and there's consequences for everything that you do, ma'am.
And what have you been doing since then?
Working, staying out the way, raising kids and grandkids, and taking care of the wife.
All right. Well, I am awaiting. I didn't see counsel an attached proposed order, so my law clerk went to grab me one. So as soon as we get that, I will read it into the record and sign it. So just give me a minute.
Thank you, Your Honor.
Yes, ma'am.
All right. Thank you. application to set aside the following conviction was filed on February 12th, 2026. And it looks like it was delivery, manufacture, or controlled substance less than 50 grams of attempt, and that was under this docket. The court finds the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has had no convictions for an assault or crime set aside under the statute during their lifetime, and there are no criminal charges pending against the applicant. The applicant has not been convicted of any criminal offense during the applicable time period required under the statute, and the applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside, and has not previously had a felony conviction for the same offense set aside pursuant to the statute. The time period for the conviction listed in item 1 has passed. And an opportunity has been given to the Attorney General, the State Police, and the prosecuting official to contest the application, and no one has. Circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of the application more than warranted justify setting aside the conviction, and it is consistent with justice and public welfare. The application is granted as to the conviction listed in item 1. And pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in the case to which this order applies. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Sir, if you were here, I'd be handing this to you and shaking your hands and doing it virtually. If this is not entered in the next 4 weeks or so, counsel, please let me know so we can make a phone call. They're getting at it quicker and quicker, but if it does fall through the cracks, we've seen that happen now and again, please let me know. The final order of this court, sir, is that you take those fine children you raised and grandkids out for a celebration. 36 years later, it is time to celebrate. Congratulations.
Thank you.
Thank you. That's all.
Thank you, Your Honor.
Thank you.
I'm free to go.
You're free to go.
Your Honor, it is noon, but I understand we do still have a lot left. Do we want to keep going, or are we taking a lunch break?
12:30 is when your stuff starts with council.
I have to be, I'm finishing at 12:30, so, because I have a meeting with judges from another county, so, Nancy, you're good to go till then.
Okay.
Yeah, if I can run to the restroom.
Yeah.
I just go in the jury room, so I'll be like 2 minutes, and then I'm good.
This is docket 23-845 FH and 23-842 FH. People of the state of Michigan versus Rayshawn Thomas. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Thomas, who is standing to my right.
Mr. Thomas, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness? Have you had an opportunity to speak with your attorney?
Yes.
All right, this is a final pretrial conference, and so we set these so we can figure out what's going on in your case, keep it moving forward, and then if you want to go to trial, we know that that's gonna happen. I don't allow a plea on the day of trial, because if I did, then somebody else would be denied that time block because you wouldn't be using it and there's not enough time to get another trial. So that's why we have these, to make sure we're all on the same page of what's going on. So on behalf of the people, has there been an offer?
There has been, Your Honor. Let me kind of explain what's going on here. I had a chance to talk to both of my victims yesterday, so actually gave a new offer to Attorney Goodrich yesterday evening at around 4:30. My understanding is that he has given that plea offer to Mr. Thomas, but Mr. Thomas does want a little bit more time to think about that plea offer before moving forward on it. Talking to your court staff, I do believe that there is a time available on Friday at 2 p.m. to potentially set this for a plea. At this point in time, I believe it would be best to set that for a plea on that day. If the plea does not go at that time, he decides to decline the plea offer at that time, then we'll be moving forward to trial.
At some point, there was going to be a polygraph, and there was a.
And that was done, Your Honor.
We've had so much work on both these files, all of that's been done, so we are ready one way or the other.
We will be ready one way or the other, Your Honor.
All evidence has been turned over?
That's to my understanding, yes, Your Honor.
Mr. Goodrich, all the work's been done, evidence, all of that.
Yes, Your Honor.
What is the offer for today's record?
Yes, Your Honor. The offer would be to count 3 felonious assault, which is a 4-year felony, and an added count 9 of home invasion second, which would be a 15-year. Upon successful plea and sentencing, count 1, home invasion in the first degree, counts 2, 4, 6, and 8, which are all felony firearm charges, count 5, a felonious assault, count 7, a possession of firearm by a felon, and the habitual offender second would be dismissed. Additionally, 23-845-FH in its entirety would be dismissed. There would also be an agreement for a sentencing to be at a fixed minimum of 43 months, and for all victims to be able to make statements at sentencing. And if there was any restitution, that would be determined at the time of sentencing. In running guidelines on this case, Your Honor, if Mr. Thomas is to go to trial and get found guilty of everything, the guideline range I have is 78 to 162 months, plus an additional 24 for the felony firearm. And under this plea, Your Honor, of the home invasion second and the felonious assault, the plea offer would have a guideline range of 43 months, which would be that minimum that we would be agreeing to 86 months.
So the offer would be.
To an added count of.
Yeah, I got that, but I mean, you said, so you would be agreeing to the 43 months, so your.
Correct.
The plea is that he's serving a minimum of 43.
Correct, Your Honor.
Okay. Which is a little bit, it's like 3.5 or 3 3/4 years or something like that. Okay. Full, fair, accurate, and complete?
Yes, it is, Your Honor.
Full, fair, accurate, and complete, sir?
Yes, ma'am.
All right, and the guidelines that you were talking about were on for the maximum and the minimum, depending whatever he decides, that was on the 23 file.
That is on the 23
I'm sorry,
file.
23-842 FH file.
Correct.
Okay, that's what my notes reflect, okay. And you need some time to go over that, and we'll be ready to either reject or accept Friday at 2 p.m. and that would be, what is that, May 1st?
That is correct, Your Honor, yes.
So you want that extra time?
Yes, ma'am.
All right. I'll see you then.
Thank you, Your Honor.
We're gonna have to clear the courtroom for HYTA sentencing.
Is there anything else left?
There are other sentencings, we could do those.
Why don't we set, why don't we-
And HP as well.
okay,
We can do one of the sentencings that is public, Your Honor.
okay. We'll save some time that way.
We will do. We'll do Frank Moore.
This is docket 256354 FH, People of the State of Michigan versus Frank Willie Moore III. Counsel, your appearance for the record.
Good afternoon, Your Honor. APA Bart Luxon on behalf of people of the state of Michigan.
Assistant Public Defender Jacob Riley appear on behalf of Mr. Moore, who is appearing via Zoom.
Sir, please raise your right hand. I need you to unmute yourself. Can you unmute yourself too? Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury? You need to unmute yourself. Can you do it?
I hit it twice to ask him to unmute. You can do it himself, yes.
All right.
Okay, can you hear me?
Yes, I can. Do you swear to tell the truth, whole truth, nothing but the truth under penalty of perjury?
Yes, sir.
Thank you. Put your hand on. You're in agreement with not standing next to your attorney, is that correct?
Yes,
All right. You pled guilty to retail fraud, first degree, punishable by 5 years. You recall that?
yes, I do.
Have you taken any medication yesterday or today?
No,
Are you supposed to be on medication you're not on?
I'm just taking blood pressure medicine.
Okay, but that doesn't interfere in your ability to understand the court or your attorney, is that correct?
No, it doesn't interfere, no.
All right. Is there any medication you're supposed to be on that you're not on?
No,
Any sign of fever, COVID, or other illness?
no,
All right. You've had enough time to talk with your attorney about sentencing?
yes, ma'am.
And on behalf of the people, any corrections, additions, deletions?
Yes, Your
No.
Honor.
Oh,
In regards to the criminal history, I will state, for the current offense, it is currently marked as status at time of offense and it says none. But Your Honor, based off of my conversation, actually with the probation officer from 55th District Court, he would still be on probation for the indecent exposure, which is number 33 on his criminal history. The whole reason that he was able to get into inpatient as quickly as he was is because he was still on probation in that order, is my understanding.
So, Mayor, I believe at the time of the incident in this case, he was on bond for that indecent exposure. And he began his, the case was adjudicated sometime after this incident.
And so we could change that to on bond. The people would have no objection to that. Well, actually, I'm seeing, oh, yes, it appears that the plea happened in February of 2025, and then the sentencing happened in November of 2025 when this case occurred. So he was on bond at the time.
Okay. I've got that.
And that would be the only correction to the body that the people have, Your Honor.
Any other corrections? On behalf of the defendant, any corrections?
The defense has no corrections to the body.
How about guidelines?
Yes, Your Honor, I believe there are some corrections to the guidelines. Looking at PRV two, it is currently scored at 10. That PRV two being prior low severity felony convictions. However, Your Honor, that would be for 2 prior low severity felony convictions. However, Your Honor, looking at his criminal history, I am seeing 4. I am seeing on page 4, number 2 of the criminal history, I am seeing 2 felony theft cases from Indiana. And then in 2008, Your Honor, I am seeing a large, 2005, I apologize. I'm seeing a larceny in a building and a uttering and publishing. Those would be on page 13, Your Honor, number 23 and 24 of the criminal history.
So you're proposing,
So I would be, say, PRV 2 should be 30 points, Your Honor, as he has 4 felonies in his history.
any objection?
No objection.
PRV two is 30. That changed the total unless there's any other changes.
There
made
are
by-
other changes to the
Okay.
PRVs, Your Honor.
Okay.
PRV 6 is currently scored at 0. PRV 6's relationship to the criminal justice system. I believe it should be scored at 5 points, which is on probation, on delayed status, or on bond, awaiting adjudication or sentence for a misdemeanor. And as we had just established, that was corrected, so I believe PRV 6 should be 5 points.
No objection.
It is 5.
That would change the total PRVs to 80, and that would change the level to F.
80 is, how about 90? No?
Maybe I did my math wrong, Your Honor, let me double check. I'm counting 80.
Okay, maybe they did it wrong. Okay, so 80. All right, thank you. And it's a level F.
Yes, level F.
Any changes to the OBs?
Yes, Your Honor. OV 13 is currently scored at 0. OV 13, Your Honor, is in regards to continuing pattern of criminal history. Those are for felonies either charged or uncharged. Looking at Mr. Moore's history, he currently has, obviously, he's before Your Honor on a retail fraud, which is a property crime. And then, Your Honor, on 2024, number 31 and 32 on his criminal history, he has 2 domestic violence 3rd offense notices. They were ultimately dismissed. However, Your Honor, as I had stated, under OV 13, all crimes, including the sentencing offense, must be counted without regard to whether the offense resulted in a conviction. So I believe that OV 13 should be scored at 10 points. That's stating that the offense is part of a pattern of felonious criminal activity involving a combination of 3 or more crimes against a person or property, or a violation of MCL 333.7401.
Any objection?
No objection. Your Honor.
OB 13 is 10. Is there any other?
No, Your Honor.
So that's a total of 15, level what, 2?
That would be level 2, Your Honor.
And guideline,
I have 12 to 24.
an objection?
No, I believe that's correct. Your Honor.
I've changed basic information sheet and I'm also under the recommendation narrative changing the range to 12 to 24. All right, anything else?
No other changes, Your Honor.
I'm a victim here.
No, Your Honor, this is a retail fraud.
Okay. And
No, the property was returned, so there's no restitution requested.
thank you. It says here, Luke Goodrich was here for the plea, is that correct?
That's correct. He was in my place on that date.
Okay, so I'm going to note him for a plea and you for sentencing. Cover page, basic information sheet, and then inside. And then that should be all the corrections. And have the people?
Yes, Your Honor. Looking at the defendant's criminal history, he seems to have a quite the arrangement of different crimes, mostly involving theft, some involving some violence, domestic violence, some controlled substance. Ultimately, Your Honor, the defendant, I believe, is in Cedar Roots. I do believe that is the best place for him right now to get the treatment that he needs. So I'd ask that you follow the recommendation of probation in this matter. Thank you.
Counsel?
Yes, Your Honor, as we can all see, my client does have a lengthy criminal history. I think he's had a problem with alcohol all of his adult life, but really it has taken over his life in the last 10 years. Since he was taken into custody on October 17th in this county, he has completed the CATS program at the county jail. He has since transitioned to Cedar Roots, where he is now. He entered into Cedar Roots on March 10th. He expects on May 5th to transition to Sober Living in Lansing. Safe Harbor, I believe, is the facility. So he's continuing working on this issue. I think he'll tell you, as he told me, that he has really changed a lot in himself since he began working with cats, and certainly since he's been at Cedar Roots. So I think he has a positive outlook going forward, and asks the court to adopt the recommendations in the pre-sentence report.
Thank you. Sir, what have you learned from this?
I've learned a lot. I mean, I really am glad that I had the time that I had in the county jail to get everything right. And then this has been a big help over here too. It has really been a big help. Now, if I had to do it all over again, I would. To be honest with you, because I've learned a lot.
Are you still on probation on the other file?
I just got put on probation since I was in jail, but it's only 6 months. But it's going to be it's non-reported probation.
I'm sorry, it's gonna be what?
Non-reporting.
Okay. All right, sir. I don't know how you've gotten so lucky, but you have a horrible file here.
Yes,
I mean, it's horrible. Aren't you old enough to do better?
Yes, I am. Yes, I am.
I mean, how much of your life has been spent with police officers and behind bars?
Too much of it. Too much of it. But I'm saying I'm getting this right now. I've seen the light since I've been incarcerated. This little time I've been incarcerated, I've really. It was just the alcohol was the main result of all my charges.
36 times. And you got domestic violence, retail fraud, indecent exposure, theft. I mean, have you ever worked?
Say it again.
Have you ever worked?
Yes, I have.
Well, sir, none of us like the cost of anything. It's all going up. Part of it's the economy and the politics and all of that. But part of it is because people like you decide to steal things and the stores have to make it up so they can stay open for the rest of us. So we're paying for your crime every day. Quit it.
Yes, I understand that.
But you know what? I don't have to do all this. It's a lot of work for me, law enforcement, lawyers, prosecutors, everybody. And if you decide to keep doing this in our community and you are lucky enough to get me, you may very well spend a lot of time in prison. Because I will clearly know and understand that you have yet to keep your promise and learn what you're supposed to do.
And I will. You don't have to worry about me. I promise that.
Well, 36 times, we worry. Try
I
getting to
understand.
37, because I'm not gonna be happy with the 37, sir.
I understand.
All right, sir, you're gonna be on probation for 24 months. If you do well after a year, you can get off. If you do poorly, I can keep you on for 36 months or basically I can move you on up to 5 years. I can also send you to prison. Make no
Yes, I
mistake,
understand.
if you keep committing crimes, that's exactly what I will do.
Yes,
I will
ma'am.
find that you are a danger to yourself and others and you can't stop your criminality, so I have to deter you by putting you in prison. Have I been clear?
Yes, you're clear. Yes.
Great. You shall not use, possess, consume, purchase, or be in the presence of any alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of that, you will present a prescription from a licensed medical physician within 24 hours. You will not violate the law of this state or any other. You need my permission to leave the state. You will complete your Cedar Roots program, including any aftercare, sign all necessary releases so we can verify that you're doing what you need to do. And you will then be moved into sober living and comply with all of those requirements. If you violate the requirements of Cedar Roots or sober living, you will be violating my orders. You'll be brought immediately in front of me and it won't go so well, sir.
Yes, I got you.
Will not engage in any assault, abusive, threatening, or intimidating behavior. You'll not have verbal, written, electronic, or physical contact with anyone housed in the Michigan Department of Correction or who is on probation
Yes, ma'am.
or parole unless you're all in good standing and we know about it. You will contact probation within 24 hours of your release from Cedar Roots and they can keep all your appointments. And I suspect you don't have a driver's license and all of that, so you certainly can do this probation on Zoom or as directed by probation as long as you are compliant.
Okay.
You will comply with all written and verbal orders of probation and allow probation in your residence at any time for probation supervision. You will be part of a work seek program and get a job not under the table, but with a real paycheck. You will, and if you're not able to work, I want proof of that. If you're on SSI or SSD or whatever it is, just verify that and we'll comply with those terms.
All right.
You must submit to a search of your person and property, including but not limited to your cell phone, vehicle, residence, and computer without a warrant if probation has reasonable cause to believe you have items that might violate the conditions of your probation. You must report any arrest or police contact, personal protection order placed on you, loss of employment or change of residence within 24 hours. Weekends and holidays are accepted, so if something happens on a Friday, tell us on Monday, if Monday's a holiday, tell us on Tuesday.
Okay.
While this says that you need to work a minimum of 30 hours per week, I don't know if that's in your best interest or not, so you can start off part-time and then go to full-time. I want you to follow first and foremost the recommendations of all of your treatment providers and then work your way up to full-time and not give your employer any cause to terminate you. You will serve 365 days jail with credit for 76 days, the balance is held. You'll serve any or all of that time and possibly prison if things don't go well. You'll pay a crime victim's assessment, the amount of $130, and a state cost in the amount of $68. And waiving fines, cost of attorney fees, finding that you are indigent. The $198 can be paid over time once you are employed, and probation will not be held over if these are not paid. Those are just the mandatory fees. Will not use, possess, purchase, or be in the presence of any weapons, guns, ammunition. And if anybody, when you go to someone's house or anybody around you has contraband, you just walk away, leave that premises. Because you may not get in, or you will get in trouble, they may not get in trouble. Do you understand?
Yes.
All right. So you'll meet with probation within 24 hours, you'll set that appointment, then meet with them, and anytime they want to meet, you'll meet. You have 42 days to appeal and to request appellate counsel. Counsel will be sending that to you and proof of service to the court. Anything I didn't address?
No, Your Honor, thank you.
I take there was no restitution, I didn't see any.
No, Your Honor, it was all, the property was all taken back from the store. Or all, it was all
Yes.
returned to the store.
Counsel, anything further?
And nothing further, Your Honor.
Good luck to you, sir. I hope you do very well.
Thank you very much.
Thank you.
That's okay.
Hi, this is the Forensic Center.
Which plea is it?
The forensic center is good to go.
It's a trial.
Mr. Doherty is not scheduled for today. When is he scheduled for? Friday. He's scheduled for Friday.
Via Zoom?
Friday? Yes, I believe.
Via
I
Zoom.
don't- As far as I know.
Okay, thank you. We had it on our calendar for today. Thank you.
Mr. Jackson, here is on Darren Herb, which we have a plea set on, but we could potentially move that to another day.
Well, if we can do these really quick, I'll just go late to my meeting. Otherwise, I gotta go.
Well, not 300 words a minute, quick though.
Yeah, but not too quick for Nancy.
Yeah, let's just set for another day.
Mr. Jackson,
Yes, we're ready.
let's just do at least one of them.
Okay.
Turn it on.
See, I'm here. All right, this is docket 256354FH, people of the state of Michigan versus. Is it Frank Willymore?
No, dear.
No, Darren Herb, Your Honor.
Or Darren Herb the second, okay. Sorry, I got other paperwork in my hand. All right, counsel, your appearances.
Good afternoon, Your Honor. APA Bar Bucks on behalf of the people of the state of Michigan.
Good afternoon, Your Honor. Brian Jackson on behalf of Mr. Herb, who is present in the courtroom to accept the people's plea offer.
So please raise your right hand. Do you swear or affirm testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Put your hand down. You taken any medication yesterday or today?
No,
You're supposed to be on medication you're not on?
no, ma'am.
Any sign of fever, COVID, or other illness? You've had enough time to speak with your attorney?
Yes, ma'am.
And you still reside on Ridley's Road?
No, ma'am.
Do I have the new address? Is it on Ridgewood Avenue?
Yes, ma'am.
Okay. And are you a US citizen?
Yes, ma'am.
Graduated high school?
Yes, ma'am.
Employed?
Yes, ma'am.
What did you do?
I own a handyman business.
Okay. What's the offense you're pleading to regarding probation, parole, or bond conditions?
No.
What is the plea offer?
Your Honor, the defendant will be pleading in this matter to carrying a concealed weapon, count 1. Upon successful plea and sentencing, the habitual offender notice will be dismissed. Additionally, Your Honor, there is a case that is in front of our office that is Lansing Police Report number 26-00926. The people will agree not to prosecute that. However, Mr. Herb will agree that any restitution in that matter will be addressed at sentencing in this case.
Full, fair, accurate, and complete.
Yes, Your Honor.
Full, fair, accurate, and complete.
Yes, ma'am.
And counsel, you're waiving reading the habitual.
Yes.
As to count 1.
Yes, Your Honor. People of the state of Michigan versus Darren J. Herb II, State of Michigan, County of Ingham. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant in count 1 carrying concealed weapon on or about July 30th, 2025 at Eifert Road and McHugh Road, Holt, Michigan, 48842, Ingham County, State of Michigan, the defendant did carry a dangerous weapon, to wit, a knife, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, Chevrolet Blazer, contrary to statute. This is a felony that is punishable by up to a maximum of 5 years or $2,500, And under statute, there is mandatory forfeiture of the weapon or device. Court to order law enforcement to collect DNA identification profile sample before sentencing or disposition, without taking the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you just understand what was just read?
Yes, ma'am.
So you understand weapons carrying concealed as a felony punishable by 5 years or $2,500. There'll be mandatory forfeiture of weapon or device and any contraband that was found. If any.
Yes.
And just to clarify, Your Honor, that there were multiple knives that were taken from the scene, so they would all be
the
forfeited.
contraband will be forfeited. Do you understand that? Unless they didn't belong to you, they belong to someone else.
They do.
Okay, sir. And the restitution on the dismissed file will be on this file, and if you disagree with the amount, your attorney just sets a restitution hearing, and then I'll determine the amount. It can go up, it can go down. Now, I don't know about those knives. If they were unlawful, they will remain forfeited. If there's some lawful ones, you can send me an order and those could be returned if it's appropriate for him to have.
Thank you, Your Honor. They're his father. I'll tell you about that at sentencing.
Okay, so if they're your father's, then he can come, and is he still alive? Okay, so he can go get them, but we'll order that sentencing, okay? Sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, ma'am.
Did you understand what you read? And you understand additionally that it's in there, but I always go over it, that you're also giving up your automatic right of appeal. If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal. Did anyone force, threaten, or coerce you to plead? Anyone promise you anything? You're pleading, that would be other than the plea agreement, and you're pleading of your own free will? After you spoke with your attorney, and you've been satisfied with the representation of your attorney? Okay, I'd like to see that happiness, so I was asked. Okay. He always does a nice job, but you have to be one of his best fans from your look on your face. So, all right. Good. All right, sir, as to count one, weapons carrying concealed, how do you plead?
Guilty.
And sir, other than the plea agreement, has anyone told you what I will do as sentencing? So I don't make up my mind until sentencing, so they couldn't have told you. So that's very good. All right. And sir, did this offense occur on or about July 30th, 2025?
Yes, ma'am.
In the township of Delhi County, Bingham State of Michigan?
Yes, ma'am.
At a specific location known as Eifert Road and McHugh, M-C-C-U-E Road?
It wasn't acute, but yeah, close to it.
Close to it, okay.
It was Harper.
Harper, okay, I'm just gonna strike that and put Harper, so Eifert and Harper. But you would agree that that's still in Delhi Township, Bingham State of Michigan?
Yeah.
And you were pulled over by law enforcement, were you in a vehicle?
Yes, ma'am.
And why did they pull you over?
I didn't have a sticker on my license plate.
Okay, and were you in a Chevrolet Blazer?
Yes, ma'am.
Were you the driver?
Yes, ma'am.
And did they ask you to step out of the motor vehicle?
Yes, ma'am.
And did they search your vehicle?
Yes.
Did you give them permission?
No.
All right. Did they see anything that caused them to search it?
No.
Yes.
Yes, yes, ma'am.
And what would they have seen?
The knives.
Okay, so once they saw that, then for whatever reason, maybe it's the length of the knives, but certainly officer safety or what have you, they then searched the vehicle. And they found was there a gun or just a knife?
It was just a knife.
It was just a knife, okay. Sorry, I assumed there was a gun, that's what we usually see. So then you had a knife that was, that you would agree was a dangerous weapon?
Yes.
Well, you hesitated, you agreed that a knife is a dangerous weapon, right? We all cut our meat with that, we could cut our hands with that, we could cut someone else with that, right?
Absolutely.
Okay. And was the weapon contained in that Chevrolet Blazer?
Yes, ma'am.
And was it a size that was not lawful for you to have in that vehicle?
Yeah.
Okay. And you would agree that a knife is a dangerous weapon?
Yes, sir.
All right, on behalf of the people, any additional questions?
People are satisfied, Your Honor.
Counsel?
No further questions.
Our counsel, where promises, threats, or inducements other than those made on the record,
No, Your Honor.
No, Your Honor.
this court will have a court roll.
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been committed voluntarily, knowingly, and understandingly, made without undue influence, stress, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count one will enter the habitual. Fourth is dismissed in its entirety, along with the people not issuing on LPD number 26009226. And restitution from that file, if then we'll transfer this file and we'll see what happens with that, if there's a hearing or not. Any outstanding warrants on both of those, on both that file and this file are hereby recalled and dismissed. And we'll talk about which specific knives are returned to the father and which one or ones are forfeited. Is there a sentencing date?
June 23rd at 10 a.m.
Is that me with your schedule, counsel?
Yes, Your Honor.
Sir, please go down to probation and make a keep appointment with probation so we can go to sentencing. They'll do a pre-trial, a pre-sentencing investigation report. We'll all talk about that sentencing. Your attorney can direct you further. Bond and bond conditions are continued. Thank you.
Thank you. Thank you, Your Honor.
We do have the height of sentencing, but it is also 1240.
Nancy, you want to do that or no? I leave it up to you.
No. I don't care, but kept your promise not to go 300 words a minute. But you went 320 words a minute.
Oh, geez. Okay. Let's do it really quickly.